Good morning to everyone. Welcome to this third Quaestio Facti workshop. We have been trying to organize this meeting for a while, for a few years right now, and we have cancelled twice for pandemic reasons. So first thing I'd like to do is to thank the five professors here, Professor David Enoch, Professor Rinat Kitai-Sanjero, Professor Amit Pundik, Professor Boaz Sanjero, and Professor Talia Fischer for being here, for your patience in the troubled organization of this workshop, the several organizations, and for your willingness to join here at Girona. We hope you have a good time. Also, while this time now, we are finishing the editing of the journal's fourth issue, the Quaestio Facti fourth issue. So I would like to use this time to thank all the people that have contributed with the journal in very different ways, submitting papers or doing blind reviews or correcting drafts. Thank you so much, all of you. I believe that the journal is doing very well because of the joint work. So thank you all. And now, I will leave the floor to Professor Laura Manrique and Professor David Enoch for the first session of this morning. Thank you.
Okay. Thank you. Good morning. As Diego said, we are about to start this first talk in the third Quaestio Facti workshop on Evidential Legal Reasoning in Israel. The key speaker is Professor David Enoch from the Hebrew University of Jerusalem, who is a very well-known author in areas such as social, political, or moral philosophy. He has published books in papers in important places. Just to mention three, we can, as an example, for instance, we have Taking Morality Seriously from Oxford University Press, or his paper Political Philosophy and Epistemology, the case of public reason in Oxford Study in Political Philosophy. Another paper, Not Just a Truthometer, Taking Oneself Seriously, but not too seriously, in cases of peer disagreement in mind. Today, he presents his papers, Does Legal Epistemology Rest on a Mistake? Professor, you have around 40 minutes, and then we have time to the discussion.
Thank you very much, Laura. Thank you all for showing up. I want to thank Diego and Victor for all the work that always put into it, and so far I've been having a good time. We'll see if this changes now during the session, but I'm very happy to be here. I also want to note that the paper was co-authored with Levi Spector and with another author, Talia Fischer, something like this, so that if there are hard questions during the discussion, you could direct them to the other end of the table. Okay, so the paper engages a general topic about legal epistemology, and indeed, at the end, I'll say a few words about legal philosophy, even more generally than that. But the paper originates from our discussion, the same three co-authors, of statistical evidence and the proof paradoxes in what is by now an old paper from 2012. And as a part of the discussion of the proof paradoxes, the question of whether statistical evidence should be taken as seriously as non-statistical or direct or eyewitness testimony or something along these lines, we had something to say about that. And we were not in any way the first ones to do it. Amit did it and others too. We tried to draw connections between the legal discussion and the epistemological one, because there are some purely epistemological issues and puzzles that raise what seem to be analogous concerns. And over the past few years, I think it's safe to say that many epistemologists, people not in law schools, in philosophy departments, and sometimes even without a legal education, have become excited about questions in legal epistemology. the proof paradoxes, but not only them. Again, this is not new. Hardly anything is ever new, but it's you can see things like this in the past, but there's been more of that recently. And of course, that's good, right? We want epistemologists to get interested in theory of evidence law, but it also creates problems. And this paper obviously is about one of the problems. After we completed the paper, I completely by accident came across the following quote from Catherine the Great. Catherine the Great apparently was a really interesting dictator. She was extremely smart, apparently ruthless, also conscientious, and extremely well educated. And she was in touch with many philosophers. And in a letter to Diderot, she says, or reportedly says, the following: "You philosophers are lucky men. You write on paper, and paper is patient. Unfortunate empress that I am, I write on the susceptible skins of living beings." And I think that Catherine the Great was right in an important way that has implications to how we should be doing legal philosophy in general and legal epistemology in particular. So this is what I'll be talking about. How the observation from Catherine the Great undermines at least some of the ways in which epistemologists have taken interest in evidence law theory. Now I should say, the title, I think it's a nice, snappy title, but most snappy titles are imprecise, right? It's not as if we argue against all ways of doing legal epistemology. There are many things that you can do that are perfectly fine. We are arguing against, at least roughly, the attempt to do legal epistemology by doing epistemology. So, for instance, to think that the way in which we should make progress on whether or not some piece of evidence is admissible is whether or not it supports knowledge, in the same sense of knowledge that we employ when we do epistemology. Things like this. There'll be more about this later on, of course. I want to also note really briefly that even if everything we say is right, even now restricting our attention just to the cases in which, to the problematic way of doing legal epistemology, that too may be useful, but in a kind of an upside down way. Because you may say something like, look, maybe if we are entitled to just do epistemology when we do legal epistemology, we can understand a doctrine. And this will, in a way, count against justifying the doctrine. Because then we'll say, but we're not just doing epistemology here. We're not writing on patient paper. We're writing on the susceptible skin of living beings. And so it may play a debunking role. It may explain in a debunking way some intuitions we have about legal epistemology. Okay, so much for the context, for number 0 in the handout. I'm very proud that I have a number 0 in the handout. And I'm proceeding to number 1. This is again a bit by way of background, and it won't surprise, I think, anyone who ever thought about evidence law. So just to say something about the relevance of truth to evidence law. Well, it seems very clear that truth matters when it comes to the law, and so when it comes to evidence law, it's not as if you want your evidence law to be indifferent to questions of truth or truth conduciveness or truth likelihood. Of course, truth matters. It may matter, it certainly matters instrumentally. The ability of the substantive law to achieve whatever it is that it's supposed to achieve depends on it not being wrong too often about the facts. But it may also be important instrumentally. It's definitely important instrumentally. It may be also important intrinsically. I don't think we need to decide this now. Truth obviously matters. Just as obviously, though, truth is not the only thing that matters to evidence law, to normative evidence law theory. You may think about so you may think about inadmissibility in different ways, right? If you want to rule some kind of evidence inadmissible because it may bias the fact finder, that may be explained by the relation to truth. But if you want to rule out some evidence because it's a fruit of the poisonous tree, well, that's not explained by truth, but it's explained by other really important values, right? So I think the obvious thing to say is that truth does and should matter to evidence law, but it's not as if truth is the only thing that matters. So when I'm about to argue in the next section that knowledge doesn't, it's not because I think that only truth does. Other things also matter to evidence law, just not epistemic things. and in particular knowledge. Okay, so this is now going to be the heart of the argument, section 3. First, just about knowledge, and then in the next section, I'm going to really quickly generalize it to other epistemic concepts. Okay, so not just about knowledge. We may formulate our evidence law regime in knowledge terms. We may formulate our evidence law regime with epistemic aims like knowledge. For instance, and there are some examples on the handout. You may want to make sure that fact finders do not find that P unless they know that P. Right? If that's a rule that you want your evidence law regime to abide by, then you're giving knowledge pride of place in your evidence law theory. You may want to make sure that an accused is not convicted unless they are known to have committed the crime. Now, these are plausible sounding things. They give pride of place to knowledge. Or in torts, you may think something like, no one should be found liable in torts unless they are known to have committed the relevant wrong. Okay, that's going to be problematic because the standard of proof in torts is much lower. So maybe, as it is on the handout, unless they are known to have probably committed the relevant wrong, or something like that. Or you may want something more general. You may want to say that the law should never proclaim that P unless the relevant legal official knows that P. Right? So these are all plausible sounding things that you may want to insist on when you're doing normative evidence law theory, and all give pride of place to knowledge. Now, when I say they give pride of place to knowledge, or they assign value to knowledge, that does not necessarily mean that they assign absolute value to knowledge. So people may think that these are important aims for your evidence law regime to have, but there are also other important aims and values, and sometimes other values will trump this one. That's okay, right? I don't want to caricaturize my imaginary interlocutor. But it's clear that if these are some of your aims in your evidence law regime, then you are assigning value to knowledge. Okay. So here's the question that I want to encourage you to consider. Suppose there are cases in which we have to decide, there's a trade-off between knowledge and accuracy. For now, all I mean by accuracy is percentage of truth. Okay? So you need to decide about some specific evidence law arrangement, some specific doctrine maybe, or a version of a doctrine. And suppose that if you go one way on it, you will achieve more knowledge. But if you go the other way, you will achieve greater accuracy. This may sound impossible because knowledge is, as we sometimes say, factive. If you know that P, it follows that P, right? But once we quantify over many cases, that's not a problem, right? So we can say, well, suppose you have to decide 100 cases. Suppose you can either insist on knowledge and then get 97 of the cases right, but also know that the guy did it, that she committed a tort, whatever, right? Or you can give up on knowledge, in some of the cases not have knowledge, but somehow, in some other means, get to 98 cases right. Right? In this kind of case, there's a trade-off. You can either get more accuracy or more knowledge. Not both, okay? So I want to encourage you to think about such cases, about cases of knowledge-accuracy trade-offs. And in particular, I want you to answer the following question, at least for now. How many more innocent people are you willing to have your criminal law system put in jail just in order to secure knowledge for your fact finders? Right? I'm sure you already realize what my answer is, right? My answer is never a single one, right? It's never a good enough justification for putting another innocent person in jail, or even for just risking putting another person in jail. Merely that we may achieve knowledge or some other epistemic nicety. Now, this is a bit tricky, so I think we need more details and maybe also another example. So, of course, in many cases, maybe, for all I know, maybe even in most cases, knowledge and accuracy will come together. So in most cases, you won't be in the situation in which there's a trade-off between the two, right? That's okay. But for our purposes, in particular for trying to understand whether knowledge really matters when it comes to evidence law. For our purposes, we need to focus on those cases in which there is a trade-off. So I'm not denying that many cases are not like that. I'm just saying that methodologically we should focus on the cases in which there is this conflict, there is the need for a trade-off. For all of these cases in which there is no conflict, there is no trade-off, knowledge and accuracy go hand in hand. For those cases, first of all, the fact that they go hand in hand, that's a contingent matter. It's not a necessary truth. And second, if they go hand in hand, then it's quite possible that it's accuracy that does the work, not knowledge. What justifies the relevant arrangement is not that it will lead to knowledge or abide by some knowledge norm, but rather that it maximizes accuracy. If you want to determine whether it's accuracy or knowledge that does the work, what you need to do is precisely distinguish between them. Okay, so here's an example, a kind of silly everyday, well, for people in universities, everyday example that's there in the paper that may help to see this point. So many of us like to make our classes at least somewhat entertaining, right? The occasional smile or laughter seems like a good idea. We also have the educational purposes, and you can now list them. I don't know what exactly they are. Helping students gain knowledge, helping them develop critical thinking, I don't know, you fill in the details. Very often the two actually cohere very nicely, because very often having a somewhat nice, positive, somewhat entertaining atmosphere in class will actually be instrumental to achieving whatever your educational goals are. But suppose we now want to know whether making sure that your class is entertaining is itself of value. In order to know whether that's the case, we need to focus not on the happy cases in which making your class entertaining will also help promote your educational goals, but rather on those cases in which the two come apart. And now we must ask, is it that important to keep your classes entertaining that you're willing to pay a price for that by doing less well in achieving your educational goals, right? That's the question we're interested in now. Instrumentally, maybe making your classes entertaining tends to make the classes better also in terms of the educational goals. That'll be great. Statistically, maybe often they come together. That will also be great. But if the question arises whether it's intrinsically important to make sure that your classes are entertaining, we should focus on just the cases in which there are trade-offs between making them entertaining and the educational goals. And I don't have a view about that, about whether we should ever be willing to pay a price in the educational goal for making one's class entertaining. But I hope you see it's a very different question from the question whether in general you have a reason to make your classes entertaining. Of course, in general you should, because often there are no trade-offs. But when there are, that's when the question is most interesting. So analogously, there are many cases in which insisting on some knowledge norm in your evidence law may go hand in hand with insisting on maximizing accuracy. There may be cases in which insisting on knowledge will be instrumental to maximizing accuracy. That's wonderful too. But if you want to join this journey with me of trying to find out whether knowledge itself should matter to evidence law, we should focus on the cases in which there are these trade-offs. Okay? So that was like the methodological detour of why it's this kind of trade-off that I'm focusing on. All right. So now, again, the thought experiment, and here I'm going to need you to participate. You are designing a legal system, say, under which people you love are going to live. You can either choose one in which fact finders don't make decisions unless they know, but there's going to be some increased risk of an innocent person, including your loved ones, being put in jail in that system. Or you can buy having a lower risk of innocent people put in jail in an alternative evidence law regime. The price you will have to pay is that fact finders will not possess knowledge, or will sometimes not possess knowledge. With this thought experiment, if you, again, and I ask you, how many more innocent people are you willing to tolerate in your jails, just in order to secure knowledge for the findings of your fact finders? Not because of some other instrument, just for that. And here, for the life of me, these are things we've been giving in talks and talking to people for a while. I just cannot fathom how anyone can answer anything other than zero. And the thought that just so that we can have this epistemic nicety for some of our decisions, that justifies, we are writing on the susceptible skin of living beings. Maybe it's okay to accept a higher risk of putting innocent people in jail for some reason. But not for this reason. Not just in order to achieve this this epistemic, star that we can put on the fridge or something. That's what we call knowledge fetishism. That would be a knowledge fetishistic. Okay, so you may think, and rhetorically I agree with you, but not substantively, that a part of the force of the argument so far depends on it being about, specifically about false convictions. But I actually think that it applies to false acquittals as well. Now, of course, we know that at least we tend to take false acquittals as less of a problem than false convictions. That's fine. But false acquittals must be a very, very big deal because, let me rephrase it. If your criminal justice system can be justified, or even can sort of remotely in the vicinity be justified, then false acquittals must be a big deal. Here's the proof of that. The criminal justice system has tremendous, horrible costs, not just in terms of money, also in terms of the suffering of people, including of the suffering of innocent people, say, typically family members of the people that you punish, right? If we can justify the criminal justice system, then having guilty people convicted must be really important. It must be sufficiently important to justify all these horrible costs. So we shouldn't belittle false acquittals, right? A false acquittal is a case in which someone guilty maybe should have been convicted and you don't convict them. And we already know that it's really important to convict them. Otherwise, the whole criminal justice system should be discarded as is, right? So again, now the question is different. Think about whatever it is that you think your criminal justice system achieves by way of a social good. More deterrence, which really just means less innocent victims of crimes, right? Okay, so now I'm asking the question again. You are designing the system under which your loved ones are going to live. And you can have one system that really insists on the epistemic stuff, but in which the chances of your loved ones to be assaulted, say, are a little bit higher. Or you can say, no, I'm going to see to it that the chances of them being assaulted are lower, and if the price is that there's not going to be this epistemic nicety of knowledge or whatever, then so be it. And again, insisting, just for the case of knowledge, to tolerate, say, higher crime rates, seems ridiculous to me, just as fetishistic. So now you may say, well, okay, so that's just about criminal law, right? Because I did talk about false convictions and false acquittals. And I do think that our intuition here comes from criminal law, but I don't think it's restricted to criminal law. It may not apply to all parts of the law equally. If it's a kind of a tort case that's really just about money, and furthermore, typically about insurance money, then maybe accuracy is not that important, and maybe I'm willing to pay a price in accuracy. I don't think that we actually come down on this very clearly. I'm open-minded about this, right? But there are many other parts of the law that also write on the susceptible skin of living beings, right? Custody cases. How many more cases, custody cases, are you willing to have decided wrongly just in order to secure this epistemic status for your findings? The only acceptable answer is zero. Right? So maybe it doesn't apply to all of the law, but it applies to huge chunks of the law. It's not just to criminal law. Okay, so this almost concludes section 3. Just two complications real quick. They're there at the bottom of section 2, sorry. I just made everyone flip their pages. One is that while the sort of quick and nice way of putting things is the law shouldn't care about epistemology or about knowledge, that may be a bit too strong because it's consistent with everything we say that knowledge should make a difference to the law, but in a way that is lexically inferior to other values. So whenever there's trade-off between knowledge and, say, accuracy, you go with accuracy. But as between two cases that are equal when it comes to accuracy, knowledge may play the role of a tiebreaker. That's a very weak signal. I mean, legal epistemologists who are into this kind of stuff, that's not what they want. They want a much stronger role for knowledge. But officially, we don't reject this, at least not in this paper. The second point is that you may think that we should be willing to pay a price for knowledge, not in terms of accuracy, that was my fetishism argument, but maybe in other terms. Like maybe, for instance, you can design your judicial training systems in ways that will secure more knowledge, but this will cost a little bit more money. So now the price for knowledge is not putting an innocent person in jail and not even a false acquittal, but rather some more money. Maybe that's justifiable. Again, these are all very weak ways of thinking of knowledge as relevant, but we're open to that. They're not the interesting ways in which our legal epistemology interlocutors want to go. Okay, so much for section 2. Section 3 is going to be really quick, because so far we've just talked about knowledge, but really nothing in what I said depended on it being knowledge. Think about any other epistemic status. Warrant. I don't know exactly what it means, but that's one possibility. Justification. Again, there are different accounts, but that's one possibility. You can find others as well. And we can run the same thought experiment. How many more innocent people are you willing to have in your jails just in order to have warrant or whatever for the findings of your fact finders? The answer remains 0. So we generalize by calling the relevant epistemic status the status, right? And then we're saying however you fill in the details for an epistemic status, the findings of the previous section apply, and so this concludes the positive case for the claim that legal epistemology rests on a mistake. Those parts of legal epistemology that try to incorporate into normative evidence law theory things about knowledge from epistemology or about warrant, just the status, whatever it is, they are just mistaken. At least as far as anything thus far said is concerned, nothing normatively should depend when it comes to the law on such things as the conditions for knowledge or on any other epistemic status. Okay, so that's it for the positive case for the claim. It's a negative claim, but that was the positive case for the negative claim. Okay, but because we are so intellectually honest, we want to acknowledge that there is a remaining discomfort. I'm very confident. I'm more confident in the claim that I just defended than in most philosophical claims I defend. But there is a remaining discomfort. Here are a few ways of viewing this. One is there is some linguistic evidence that knowledge does matter. For instance, think about the following sentences there on the handout. So suppose you're talking about a judge or maybe a jury member and you're saying she voted to convict without knowing the guy is guilty. It's very hard not to understand this as criticism. But if this is criticism, then that's some indication that we do require knowledge for a justified conviction. I'm not saying it's extremely strong or conclusive indication, but it's some indication, right? Or think about, a juror during jury deliberation saying something like, yeah, you're right, we don't know that he did it, but we should convict. And that again sounds weird, right? You really feel the force of saying, well, if you don't know, don't convict. Right? So again, there's some linguistic evidence pulling in the direction of saying, no. Even if you're not sure what went wrong with the argument, something went wrong with the argument, right? There's knowledge is important. Now, there may be other explanations of what's awkward about these sentences, and also there may be conflicting linguistic evidence. If you're playing the game of linguistic evidence, you should play it holistically. You should bring all of the linguistic evidence and see, right? So, for instance, think about the following. This is a juror after the fact, right? And he or she says, I did what I could. The evidence we were shown was strong beyond a reasonable doubt. Still, it turns out I was wrong. Does that sound like a contradiction? to me, it doesn't sound like a contradiction. If it's not a contradiction, it means that the standard beyond a reasonable doubt is not factive. And if so, it does not entail knowledge, because knowledge is factive. So, linguistic evidence is hard. We're going to have to take it all into account, and it doesn't speak in one voice, in one direction here. But we want to acknowledge that there's at least some linguistic evidence against our conclusion. Another kind of thing is legal Gettier cases. So I wonder, how much time do I have? Like 10 minutes?
Yeah.
Okay. Yeah, I'm going to explain it real quick. So we used to think for roughly 2,400 years that knowledge is justified true belief. But then Edmund Gettier publishes his paper and he gives examples, counterexamples. Here's one that actually does not come from Gettier. Russell gave it decades before Gettier, but didn't understand how powerful it was. So suppose you're trying to find out what the time is and you're looking at the clock. And suppose the clock is very, very reliable. So it's a very justified way of forming a belief about the time. You look at the clock and the clock says 10:39. So you believe it's 10:39. Suppose it is also actually 10:39. So your belief is both justified and true. But suppose that the clock actually stopped working precisely 12 hours ago. Intuitively, do you know that the time is 10:39? And most people answer no, that does not qualify as knowledge. But that is a justified true belief. Ergo, not all cases of justified true belief are knowledge. And this Gettier publishes this, I forget when, in the 60s, I think. It's like a 3-page paper, and it's the most widely cited whatever, and all hell breaks loose in epistemology. People try to offer other analyses of knowledge, a condition that sort of, they say, okay, knowledge is un-Gettierized justified true belief, or maybe we shouldn't analyze knowledge at all, we should take knowledge as basic, and the games go on. Okay. This is an epistemology. It has been, some attention has been given to the point that Gettier cases arise in the law as well. So this is a case from Pardo. So think about a defendant who is being framed. Namely, the police planted some illegal drug in his car, and they want to convict him now for possession of this drug. Suppose that he did possess the drug, but it wasn't the batch that the police actually planted, right? So unbeknownst to the police, there was also this illegal drug there, right? And suppose we now convict him not because of the piece that was stashed in his car, but because of the piece that was planted by the police. Is it a good conviction? Are we happy with it? And Pardo plausibly said, of course not. It's a Gettier case, right? It has the same kind of structure. Why aren't we happy with it? Here's a nice explanation. Because it's a Gettier case. Because it's a Gettier case, we don't know that the guy is guilty, and when we don't know that he's guilty, we shouldn't convict. So Gettier cases seem to also, legal Gettier cases, seem to indicate that we care about knowledge in the legal cases. Lastly, when I presented a version of the old statistical evidence paper in some talk somewhere, I was then approached by Justice Aaron, Supreme Court Chief Justice, Aaron Barak, and he said something like the following. It's not a quote, but it captures the conversation, and he did okay afterwards. So. And he said something, the interesting point I think is that it's interesting about the phenomenology of judging, about what it feels like to decide cases. And he said something like the following. I understand, of course, that any legal system is bound to make mistakes. And I understand how probabilities work. Still, when judging, it's not about probabilities at all. I seek certainty. I think of the different burdens of proof and different statistical requirements, say, requiring over 90% for beyond a reasonable doubt, right, or over 95% or something like this. I think of these things as mere instruments with which I can convince myself with 100% certainty that the defendant is guilty. If all I'm convinced of is that there's a 90% chance that the defendant is guilty, then I acquit. So he knows that you never get certainty. He knows that you're sometimes wrong. He knows that all evidence only probabilistically supports the relevant conclusions, and yet this is what he wants. He wants certainty. And I think that he's importantly right about the phenomenology of judging. Now this is about certainty, but a similar point I think can be made about knowledge. You guys can talk about percentages and probabilities as much as you want. But unless I know the guy did it, I don't convict. And again, it has the similar, it rings true. So we have these three kinds of evidence showing that there's some inconvenience remaining, despite the fetishism argument. There's some inconvenience remaining to the thought that knowledge does not matter, maybe other epistemic things don't matter for evidence law. We want to offer a tentative solution. And the tentative solution is by going two-tier. So we want to distinguish between the level of system design and the level of the deliberation of the conscientious fact finder. These are distinctions that come up in the literature in other contexts. We use roles from two concepts of rules about utilitarianism, but it comes up elsewhere as well. And the thought is something like the following. The knowledge fetishism argument clearly applies at the level of system design. I mean, that's how I put the thought experiment to you, right? I was saying something like, you are designing a system under which your loved ones are going to live, and I asked about the trade-offs. This is about system design, and there we're just digging our heels. We just think that our argument is conclusive. But that doesn't mean that you want your judges not to think in epistemic terms. In which terms do you want your judges or fact finders to think? Well, presumably in those terms, such that if they think in those terms, you will achieve more of whatever it is you want to achieve. Accuracy, other things. So ultimately, at the level of system design, knowledge does not matter legally. But maybe that's still okay to have judges deliberate on whether they know or not, because that may be, it needn't be, but it may be the best way of achieving whatever it is we want to achieve from our legal system. This nicely, I know I'm getting short on time, so I'm not going to go into all the details, but this going two-tier thing nicely deals with, with some of the linguistic evidence. It deals very nicely with Gettier cases, because from the point of view of a deliberating fact finder, you can't even formulate a Gettier case. Gettier cases are things you look at, as it were, from a third-person perspective. So we can say from system design, we don't care about this, but the judge should not convict in such cases, right? And we can say why. And I think it also nicely accommodates the point from the phenomenology of judging. So judges or fact finders are not system designers. They do something else. So different norms apply. Of course, gesturing at the possibility of a two-tier story is not enough. You have to justify it. In particular, you have to show why it is important to keep this kind of acoustic separation between the system designer and the players within the system. And there may be ways of filling in the details, but importantly, there may not. And if there is no way of filling in these details, then the two-tier story collapses. If the two-tier story collapses, we need to choose. Do we stick with the arguments of section 2 and 3, namely the knowledge fetishism kind of argument, and so say that knowledge doesn't matter, or do we stick with the remaining discomfort of section 4? If I have to choose, I go with sections 2 and 3. There aren't many things I'm more confident on than when you're writing on the susceptible skin of living beings. Epistemology is not what intrinsically matters. Okay, so that's the general view here. I want to conclude with, as I promised, something about how this is, at least for me, really a particular instance of a more general phenomenon about legal philosophy. Indeed, about how not to do legal philosophy. Because across the board, there are in the law concepts and questions about which we also have philosophical discussion. Causation is really clear. Right? Causation is one of the only places in which philosophers actually take interest in a legal text. The Hart and Honoré text is actually used by philosophers, not because it's deep philosophically, mostly I think because it involves many cases and good distinctions, but still. So you may think, look, suppose you have a question, you need to decide a question as a matter of legal policy about causation. You say, wait a second, let's bring in the metaphysicians. Because, they've been discussing the nature of causation for a while, and we're just going to plug in their conclusions about causation to what we want to do with legal causation. Similarly, for many other cases, I'm not going to give more examples. And we think that it's a mistake across the board for similar reasons how many, and now fill in the details, how much damage are you willing to do when you're writing on the susceptible skin of living beings? Just in order to make sure that you use the word causation in legal context in a way that satisfies the best metaphysical theory of causation. I mean, if need be, we can disambiguate. We can distinguish between causation sub M for metaphysics and causation sub L for law. And then we can say, well, maybe the two coincide. You're going to need to show me an argument for that. But maybe they don't. And you can't just do legal causation by doing causation. Similarly for other concepts. And as I hope you can see, that's just a generalization of the claim I started with, namely that you can't do legal epistemology simply by doing epistemology. So I think I'll conclude here.